In the rock, paper, scissors or federal government plays, who wins? Does the federal court always get what it wants, or are there limitations? While hearing cases on the question of birthright citizenship, several district courts claim the power to rule over the president. I don't remember seeing that in the Constitution. Now the Supreme Court has weighed in, deciding the case of Trump versus Casa that the lower courts are not so powerful after all. So let's take a look at this decision next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach, Rise, and Generation Be Free. I'm glad you could join me today. I remember when I did the oral arguments on this case, and well, there was a lot of bad information. In fact, a lot of judicial hubris in it. Now that we've gotten to the decision, well, okay, I still see quite a bit of judicial hubris, even though I think the court came to the right decision. Now, if you want to learn more, if you want to follow up and check the links I used, well, head to the website, constitutionstudy.com. You can look at this article in its text form with all the links to all of my sources. Now, I'll talk more about the website and some other things you can consider at the end of the episode. But for now, let's get into this universal injunctions decision. When the president signed the executive order terminating the unconstitutional view that citizenship is a birthright, it didn't take long for the lawsuits to fly. Now, with those suits, however, came courts attempting to stop the president using universal injunctions. Plaintiffs, respondents here, individuals, organizations, and states filed 3 separate suits to enjoin the implementation and enforcement of President Trump's Executive Order 14160. The executive order identifies circumstances in which a person born in the United States is not subject to the jurisdiction thereof and is thus not recognized as an American citizen. The executive order doesn't make up the circumstances of birthright citizenship. It merely implements what the Constitution and U.S. law already say. The 14th Amendment has always excluded from birthright citizenship persons who are born in the United States but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to the jurisdiction thereof is a national and citizen of the United States at birth. That's from Title 8, Section 1401 of the United States Code. Now, this generally mirrors the 14th Amendment's text. As it plainly states, this executive order only identifies what common sense and the explanation of Senator Jacob Howard Merritt, the person who submitted the text and subject to the jurisdiction thereof, to the joint resolution that would eventually become the 14th Amendment. That means foreigners and aliens do not have a right to citizenship at birth. This amendment, which I have offered, is merely declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens, who belong to families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of person. Of course, that little detail has not stopped plaintiffs and courts at all levels from claiming differently. The plaintiffs allege that the executive order violates the 14th Amendment Citizenship Clause, Section 1 and 201 of the Nationality Act of 1940. There are numerous problems with the plaintiff's allegation. First, that it violates the 14th Amendment Citizenship Clause. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Clearly, as I've already shown, to be a citizen if you are born in the United States, you must be subject to it as well. Congress agreed with this when they passed the Nationality Act of 1940. The following shall be nationals and citizens of the United States at birth: a person born in the United States and subject to the jurisdiction thereof. Not only does the executive order state the language of the 14th Amendment and U.S. law, but the policy it put forth merely implements what the Constitution and law state. It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to persons when that person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawful permanent resident at the time of said birth, or when that person's mother's presence in the United States was lawful but temporary and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. Before we get too deep into this opinion, let's be specific about what the court is being asked. The court did not decide the question of birthright citizenship, no matter how many news outlets reported it did so. The question before the court was one of injunctions. In each case, the district court entered a universal injunction, an injunction barring executive officials from applying the executive order to anyone, not just the plaintiffs. And in each case, the Court of Appeals denied the government's request to stay the sweeping relief. The government argues that the district courts lacked equitable authority to impose universal relief and has filed 3 nearly identical emergency applications seeking partial stays to limit the preliminary injunctions to the plaintiffs in each case. The applications do not raise, and thus the court does not address, the question of whether the executive order violates the Citizenship Clause or Nationality Act. Instead, the issue the court decides is whether, under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions. The Trump administration asked for a stay of these lower court injunctions on the basis that they exceeded the authority vested in those courts by Congress in the Judiciary Act of 1789. As Justice Barrett wrote in the opinion of the court, this case was incredibly important. The question whether Congress has granted federal courts the authority to universally enjoin the enforcement of an executive or legislative policy plainly warrants our review. It is easy to see why. By the end of the Biden administration, we had reached a state of affairs where almost every major presidential act was immediately frozen by a federal district court. The trend has continued. During the first 100 days of the second Trump administration, district courts have issued approximately 25 universal injunctions. As the number of universal injunctions has increased, so too has the importance of the issue. Imagine that. A nation not ruled by laws but by judges. How is that any different from the very first grievance our founding fathers brought against the king in the Declaration of Independence? That he has refused his assent to laws the most wholesome and necessary for the public good. Now, we declared independence from Great Britain for overturning our laws, so why should courts be granted the same power? The fact is, they weren't. The government is likely to succeed on the merits of its argument regarding the scope of relief. A universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. It's important to remember that, other than the Supreme Court, all other federal courts are created by, and therefore regulated by, Congress. From Article 3, Section 1 of the Constitution, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may, from time to time, ordain and establish. So where do these inferior courts get their power from? Congress. In this case, the Judiciary Act of 1789. The Judiciary Act of 1789 endowed federal courts with jurisdiction over all suits in equity, and still today, this statute is what authorizes the federal courts to issue equitable remedies. Though flexible, this equitable authority is not freewheeling. We have held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. Now, many of our legal traditions come from our mother country, Great Britain. So when the court asked the question if universal injunctions are the sort of equitable remedies traditionally accorded by courts of equity at our country's inception, they're looking back at the High Court of Chancery in England. We must therefore ask whether universal injunctions are sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act. The answer is no. Neither the universal injunction nor any analogous form of relief was available in the High Court of Chancery in England at the time of the founding. Now, while Justice Barrett went into great legal detail when she wrote the opinion, the short answer is there was no power of universal injunctions at the founding of the nation. Justice Thomas brought this out during oral arguments.
So we survived until the 1960s without universal injunctions.
That's exactly correct.
There were a few concurring opinions, but they focused on legal details. Important, yes, but beyond the scope of this episode. Which brings us to the dissent, starting with Justice Sotomayor's. Children born in the United States and subject to its laws are United States citizens. This has been the legal rule since the founding, and it was the English rule well before then. Don't you just love it when the allegedly best legal minds in the country can't even quote the Constitution accurately? As I've already shown, the 14th Amendment does not say a person subject to the laws of the United States, but to the United States itself. Not only was that not the legal rule since our founding, if it was, we wouldn't have needed the 14th Amendment. The court once attempted to repudiate it, holding in Dred Scott versus Sanford that the children of enslaved black Americans were not citizens. To remedy that grievous error, Congress passed in 1866, and the states ratified in 1868, the 14th Amendment Citizenship Clause, which enshrined birthright citizenship in the Constitution. There it has remained, accepted and respected by Congress, by the executive, and by this court until today. It must be nice to simply make up your own history to fit your needs. Yes, the Supreme Court denied citizenship, but not to children born to enslaved blacks, but to all black people. The U.S. Supreme Court decision in which the court ruled that African Americans, whether enslaved or free, were not citizens of the United States and therefore did not have the right to sue in federal court. With this type of academic malfeasance, just what can we expect from the rest of the dissent? No right is safe in the new legal regime the court creates. Today, the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding citizens or prevent people from certain faiths from gathering to worship. The majority holds that, absent cumbersome class action litigation, courts cannot completely enjoin even such plainly unlawful policies unless doing so is necessary to afford the formal parties complete relief. The holding renders constitutional guarantees meaningful in name only for any individuals who are not parties to a lawsuit. Because I will not be complicit in so grave an attack on our system of law, I dissent. Apparently, Justice Sotomayor has forgotten the fact that she just gave an example that the courts are just as capable of infringing on people's rights as Congress or the president. So why should they be allowed to make nationwide policy decisions in the form of these universal injunctions, even when the fact that they do not stand up to the law? For example, Justice Sotomayor points to a previous Supreme Court opinion in support of our birthright citizenship clause, United States versus Wong Kim Ark. From there we read, a child born in the United States of parents of Chinese descent who, at the time of his birth, are subject to the Emperor of China, but have permanent domicile and residence in the United States, and they're carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, become, at the time of his birth, a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution. Did you notice the line, are subjects to the Emperor of China? That means when the court found that Mr. Ark was a United States citizen, they completely ignored the language of the Constitution, requiring someone to be subject to the United States, not a foreign emperor. This was a direct violation of their oath of office, not to mention legally claiming a right not confirmed by the supreme law of the land. Another example of Justice Sotomayor's twisted view of history is this statement. The lawmakers who ratified the 14th Amendment understood that it would extend citizenship to all children born here, regardless of parental citizenship. As I've already pointed out, the man who proposed the amendment that added the words, and subject to the jurisdiction thereof, said on the floor of the Senate, this amendment which I have offered is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to the jurisdiction thereof is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of person. So no, Justice Sotomayor, the lawmakers who ratified the 14th Amendment did not understand that citizenship would extend to all children born here. Now, based on these warped and twisted facts, Justice Sotomayor came to the following conclusion. The rule of law is not a given in this nation, nor any other. It is a precept of our democracy that will endure only if those brave enough in every branch fight for its survival. Today, the court abdicates its vital role in that effort. With the stroke of a pen, the president has made a solemn mockery of our Constitution. Rather than stand firm, the court gives way. Because such complicity should know no place in our system of law, I dissent. Besides the fact that a Supreme Court justice cannot tell a democracy from a republic, Does anyone else find it ironic that Justice Sotomayor is calling for the courts to fight for the rule of law while she not only ignores the law, but makes it up for herself? That is not the rule of law, and neither is it a republic. It is an oligarchy where she apparently wants to rule. Just who is making a solemn mockery of our Constitution? In another example of both judicial hubris and a complete lack of understanding of the law, we have Justice Jackson's dissent. I agree with every word of Justice Sotomayor's dissent. I write separately to emphasize a key conceptual point. The court's decision to permit the executive to violate the Constitution with respect to anyone who has not yet sued is an existential threat to the rule of law. First of all, Justice Jackson is assuming facts not in evidence. She even pointed that out during oral arguments where she said,
"But here we are at the beginning of this litigation. No one has determined whether or not the government's conduct is actually unlawful. We have a district court, several district courts, and now courts of appeals that say it is, and so, as an interim matter, we are saying the government has to stop doing it while we litigate the issue of the unlawfulness."
She jumped right over the case she is supposed to be deciding and just assumes that when the president establishes a policy that follows the language of the Constitution and laws of the United States, it is inherently unconstitutional. Could that be because of who the president is? What about the courts acting beyond their legitimate powers, delegated to them by Congress, which is the actual case she's supposed to be looking at? Could it also be because she's afraid her position on birthright citizenship won't survive a court scrutiny? It appears Justice Jackson also likes to play fast and loose with the facts to get to the decision she wants. In both dissents, it appears these justices are more concerned about violating court precedent than the actual Constitution itself. Justice Sotomayor pointed this out during oral arguments.
No, we don't, because the argument here is that the president is violating not just one, but by my count, 4 established Supreme Court precedents.
I guess her law school didn't teach her that a court decision is not law. It cannot be violated except by the parties to the case. Furthermore, both dissenting justices simply made up facts and twisted the law to try to get to the decision they wanted. It reminded me of a quote by Ronald Reagan.
Well, the trouble with our liberal friends is not that they're ignorant. It's just that they know so much that isn't so.
Thankfully, 6 of the 9 justices seemed to focus on the question at hand and were willing to follow the law. Held, universal injunctions likely exceed the equitable authority that Congress has given to federal courts. The court grants the government's application for a partial stay of the injunctions entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. In other words, the injunctions requiring the federal government to give citizenship papers to those who are not legally citizens are stayed, except for those who had sued in this case. Meanwhile, the same district courts who issued these injunctions can now get to the task of deciding the underlying case. When a president follows the language of the Constitution rather than the Supreme Court, is that unconstitutional? I expect that to be a twisted set of decisions as well. So the court weighed in with what I believe is a correct decision. Universal injunctions are out. The injunctions are limited to the plaintiffs in the case and only the plaintiffs in the case. But I want to point out we still haven't gotten to the question of birthright citizenship. Those facts have not been tried yet. Now, hopefully we'll get to that because I think it's a very important point and a question I hope to be talking about more here on the Constitution Study. Now, if you want to find out more of what we're doing, head to the website constitutionstudy.com. You can join a mailing list. You can check out all the articles and videos. I have a news feed. You can ask a question. I love when people ask questions. There's plenty of content there. And by the way, go to the store and you can purchase a book or a shirt or a mug or something else to help support the work that we're doing. In fact, you can just donate to the cause to help pay for all the work that we're doing here at the Constitution Study. I don't draw a salary, so everything goes to keeping the Constitution Study up and running. Another way you can help is by supporting our affiliates. For example, I found this great course called The Miracle of America. It looks at our history, basically from the pilgrims through the founders, through the framers of the Constitution. It helps explain why things are the way they are, why the Declaration was drafted that way, why the Constitution was written that way, why we have 3 branches of government, stuff like that. Pretty good and pretty important. In fact, I liked it so much, I made a deal with the owner. Go to constitutionstudy.com/1776 study guide. By the way, that's the numerals, 1776 study guide. You go to a custom landing page just for my listeners where you can read up about the course and the instructor. But best of all, you can enroll for a free lesson on God's natural law. That's right. You get the downloadable study guide in an hour of content, audio or video, absolutely free. Now, if you like that and you want to take the rest of the course, you can sign up there for just $17.76, which I think is a pretty good deal. But your journey starts by going to constitutionstudy.com/1776 study guide and enrolling for your free lesson on God's natural law. Also, use your cell phone to protect your rights. I joined Patriot Mobile years ago because, well, not because of the great 4G and 5G coverage and not because their customer supports 100% US base, but because they believe what I believe. They are America's only Christian conservative wireless provider. They take a portion of every dollar to support organizations like NRA, Students for Life, Turning Point USA, and yes, the Constitution Study. Join me by going to patriotmobile.com/constitution and finding a plan that works for you. See if you're eligible for a discount. Be sure also to use the code Constitution at checkout to get free activation as well. Again, go to patriotmobile.com/constitution to find a plan that works for you, and then use the code Constitution at checkout to get free activation. And you can start using your cell phone to protect your rights, the rights of your family, and the rights of your neighbors. Most of all, if you can share the content we do here, share the links from the website, let other people know the Constitution Study is out here and the resources we provide. And also, it'd be nice if you brought them with you next time that you joined us here for the Constitution Study.